appeal in the matter of BN children.
Yes. Good morning, Mr. Taylor.
My Lord, may it please you, Lord and Lady, I appear for the first appellant in this matter, together with my friend Miss Littlewood. The other parties appear as follows. For the second appellant, my friend Mr. John Tuan, Queen's Counsel, who leads Mr. Nathan Aline Brown, who is delayed in another matter but will be here shortly. My Lord, for the first respondent local authority, my friend Christopher Poole, leading my friend Mr. Samuel Marks. For the father of the three oldest children, my friend Miss Hughes appears. And my lords and my lady will have received written submissions and excuse the attendance of Mr. Parker.
We have.
Acts for the
Thank you. Now, before we go any further, can I just remind the parties and anybody who's observing the hearing that this case concerns children, some of them young children, and that the usual direction applies, namely that nothing is to be reported or published which might identify the children or their family. But inevitably during the course of a hearing of this sort, I know that experienced counsel will do their best to deal with the matter, as it were, without unnecessarily identifying individuals. If we manage to get through all that without any slight slips along the way, it'll be surprising, because when you've been involved in a case of this length, it sometimes becomes very difficult to avoid mentioning first names and so forth. But if we could try to deal with it by referring, for example, to the eldest girl, the second girl, the third girl, and so forth, that would be helpful, or whatever other system suits you. Let's not please name the local authority concerned, although the court in which this case has been heard will become a matter of public record. So that's the first thing, but please don't trouble yourselves unduly if there are occasional departures from the perfect. The next thing is that we can assure you that certainly in relation to the materials that have been prepared for this appeal, we've all had a very good opportunity to study those, and to, in particular, to study the judgment and the written submissions which you all kindly prepared. We haven't, speaking for myself, exhaustively read the materials underlying the judgment, although I've certainly read the 2015 judgment of the district judge. So you can take as read a working familiarity with the facts of the case and the contents of the judgment, and if it suits you, move straight to your arguments. Before letting you do that, there are, of course, two appeals, but they're not identical in relation to the findings that are challenged. Mr. Tuan, I think, challenges everything. You only challenged the findings arising from the second girl's oral evidence. But as to that, there's a considerable overlap between your submissions. I think Mr. Tuan has one extra point in relation to his own client's case not having been adequately considered. But although there's a lot of material, the points seem to us to be fairly compact issues. So, to put it colloquially, don't feel that you have to use up your entire time estimate into tomorrow if you don't need it, but we'll allow you to use whatever time you think is appropriate to present your client's appeals.
Well, I'm very grateful for both of those helpful indications. In relation to the former, can I say that obviously there's an added anxiety in a case like this being streamed, where no doubt if a case like this is reported, there is a degree of care taken in respect of potential for jigsaw or other inadvertent identification. And that sort of, the capacity for one on one's feet to deal with that is trying. But we'll do our best. And I think the Lord's indications in respect of geography, I'm going to say also cultural backgrounds, and other such matters. Certainly for my part, I'm sure we will all do our best to avoid.
Well, I think
those.
the national and cultural background of the family in this case is obviously a relevant consideration, and will have to be referred to. But the point you make is well made.
Well, I'm grateful. My Lord, then, as my Lord has the point, we seek on behalf of the mother only to challenge those allegations which arose out of the second chance oral evidence. And so that came for the first time out of the blue and in some surprise to all the parties in the course of the hearing. We have sought to try and simplify the court's task in identifying those matters we challenge by highlighting them in the schedule of allegations, which is annexed to our skeleton.
That's very helpful. Is it A34?
Yes, that's where
those are the
first
page numbers that we're all using.
Yes.
So the judge made 20 findings, but 19 of them concerned the appellants, and one concerned as I'll call him, the first father.
Yes.
The appeal does not concern that single finding. Mr. Tuan's appeal concerns all 19 of the findings, and yours concerns a selection identified by highlighting.
My Lord, that's right. And with two points, we make the first point in the skeleton, and that is in relation to number 10, which we've
Yes.
not highlighted. And what we say is that 10 was originally pleaded, but in the light of the oral evidence, the gravity of the offence, as it were, described in paragraph 10, became so much greater. So for the first time, there's reference to the use of implements other than a stick. And then the second caveat is that paragraph 11, or quite rightly says, concerns the first father. I will, with my Lord's and my Lady's permission, seek to say a few things just about that, because it ties into the res judicata issue, because it relates to historic matters, which that in particular wasn't dealt with by the judge in 2014-15, but was before him.
Could I just ask you how this document, which you've attached, marries with the local authority's final document, which I think was the 5th of February from memory? Is it the same?
This is their final document.
This is their final document with your annotations.
Yes.
So, for example, I mean, where I'm looking at a particular passage where paragraph 14, it said originally the mother knew or ought to have known, etc. Who deleted the ought to have known? Is that the local authority?
Yes.
Because with the benefit of the second chance evidence, it considered it could prove the case that she knew.
Well, precisely so. So the next paragraph refers to active participation, which obviously indicates knowledge.
At what point was ought to have known removed? After the 5th of February?
Yes, this document is, I think, was received the day before written submissions were filed. And I think the learned judge refers to the chronology of the receipt of that, and there was no complaint made because these were all telegraphed earlier in evidence.
Well, this might have been a procedural appeal, but it isn't in fact a procedural appeal because an opportunity was given for everybody to regroup.
Yes.
And take forward. But the sequence of pleadings was that there was an opening schedule of findings sought, no doubt. The case then went on and the findings evolved.
Yes.
And this document was created after the evidence but before the written submission.
Lord, yes.
Right. So that, for instance, when the children or one of the children refers to events happening daily, the local authority in fact put it as regularly, for instance, so it shadows but doesn't exactly mirror the evidence that was given from time to time.
That's right. So one example of that would be the second child referring to issues between her assaults by the second appellant on her happening on a daily basis.
Yes.
But the judge recognising in the course of her judgment, no doubt the local authority in advance of that, that there were times when that person, that adult, was out of the country.
Okay. That's helpful.
And what then, I hope this suits the court. What I'd like to do is to identify certain passages within the judgment which address matters that are key to a fact-finding inquiry. I'll come on to precisely what those matters are, but in short term, inconsistencies, how the judge approaches those, how she approaches what we would term unrealistic or exaggerated allegations, how she approaches corroboration, and how she approaches the lack of prior complaints. And of course, in making those submissions, I'm directing myself.
The third point was inconsistencies, exaggerations,
corroboration, and no prior complaint. And I'll develop those, if I may, in due course, but the starting point is that we say this, the land judge did not deal with the issue of credibility beyond looking at the issues of demeanour, and where she sought to deal with those other points that I'll address the court on, if I may, her judgment is flawed. So in fact, what we say is left is an analysis of credibility of the second child, that doesn't go beyond demeanour. Sorry, we've just discovered this morning that we weren't to be provided, so thank you. And so it is relevant, I suggest, that the land judge was reminded in closing submissions, and I can give my lords, my lady, the references, but by mother, at her closing submissions at C147, paragraph 13, the land judge is reminded of Lay Justice McKerr's observations in Re M that any judge appraising witnesses in the emotionally charged atmosphere of a contested family dispute should warn themselves to guard against an assessment solely by virtue of their behaviour in the witness box, and to expressly indicate that they have done so. And on behalf of the father, in his counsel's written submissions, at C41, paragraph 12, the land judge was referred to the judgment of...
Do you want to stop with Re-em for the moment, just so that we take these points properly on board? Now, do we have that in the short authorities bundle?
No, I don't think so. I think
right.
We've taken a view in relation to the...
No problem about that at all, except that it would be helpful if you could remind us at some stage, and no doubt others can look this up while we continue, what the facts were in Re-em and what the contexts of Lady Justice McKerr's observations were, because I can't bring them to mind.
Well, we can deal with that. Thank you. And in a quite different case, the father relied on the judgment of, as he was, I think, Lord Justice Leggett in Sri Lanka and the Secretary of State for the Home Department. This is a C41. And there are two paragraphs in that judgment, 40 and 41, are set out in the written submissions.
C41, are we?
My Lord.
I'm working from an electronic bundle, and so I don't think assuming you're going to be able to give me bundle references.
On page 260.
Thank you very much. Can I just put the point to you, for not as a view, but for your comment? What has all this got to do with a child knowing whether or not she has been subject to sexual abuse of the gravest kind?
It's relevant to the it's relevant to the court's assessment of whether or not that child is telling the truth about the matter she says she knew. And so, for example, in the first paragraph, as part of that assessment, Lord Justice Leggett refers to the fact that demeanour is an untrustworthy guide, and rather what's much more important is the question of whether the allegations are logical or illogical, plausible or implausible, where they're internally inconsistent and contain fewer details. And in the second paragraph, paragraph 41, the second sentence, that to attach any significant weight to such impressions in assessing credibility risks making judgments which at best have no rational basis and at worst reflect conscious or unconscious biases and prejudices. And then closing, rather than attempting to assess whether testimony is truthful from the manner in which it is given, the only objective and reliable approach is to focus on the content of the testimony and to consider whether it is consistent with other evidence and with known or probable facts. And I refer the court to that for the reasons which I want to develop, which is that this learned judge did not address those matters of substance, inconsistencies, exaggerations, corroboration, and lack of prior complaints adequately, which means that we say one's left with a judgment that is largely, if not wholly, and certainly inadequately based on demeanour, because those matters do not withstand scrutiny. And so, if I may, then I'll start with inconsistencies.
And we look at, I'm sorry, because this is really rather central to your case. You've given us Sri Lanka. In which the issue was whether an asylum seeker had been tortured. So, can we just, is it possible for us to situate ourselves in that decision to see what led Lord Justice Leggett to say as much as he did about demeanour? In other words, to frame the paragraphs that you rely upon, that Mr. Toon relies upon in the context of the decision itself.
So the issue was whether or not, when the first-year tribunal had delayed for more than 3 months between the hearing and promulgating its decision, that delay in and of itself made the decision unsafe. That's paragraph 1.
Yes. And then the judgment deals with the issue of delay, generally, then the delay in the case. And then from paragraph 33, demeanour.
Was Lord Justice Leggett faced with an argument that if there was such a delay between the hearing and the promulgation of the decision, the first-year tribunal would have forgotten the impression made by the demeanour of the appellant? Was that how the issue came up?
And so he concludes by saying that, in fact, that would not have been a particularly useful aspect of the case to their decision-making process. So even if paragraph 43, even if the appellant had, through his demeanour when answering questions, given the judge the impression that he looked and sounded believable, the suggestion that the judge should have given significant weight to that impression, let alone that he could properly have treated it as compensating for the many inconsistencies and improbabilities in the content of the appellant's count, cannot be accepted. So it's a useful judgment in distinguishing, when undertaking a fact-finding exercise, between demeanour and inconsistencies.
So paragraph 31 recalls that this argument was raised in a replacement skeleton argument, so it wasn't a an argument, I think, for which the appellant had permission to appeal, and it was a criticism of the upper tribunal had upheld the decision of the FTT on the basis that the FTT had not relied on demeanour in making its decision, and the argument was then put forward in the Court of Appeal late that demeanour is a vital matter to take into account when assessing the credibility of a witness. So, paragraph 32, Lord Justice Leggett of the General says there's no warrant for entertaining at this stage. An argument was not made before the upper tribunal, not raised in the grounds of appeal, didn't form basis on which leave was given. And he then explains why the fact that the FTT didn't base its findings on demeanour didn't matter. So it's obiter, isn't it?
That's true.
All right.
I'm taking it a little bit more slowly so that I can catch up, my lady. The FTT dismissed the appellant's evidence in that case, found that paragraph 6, his account of arrest, torture and fear of further mistreatment was not credible. The UT dismissed the appeal to it and found that although there had been a delay, the findings of the FTT were not based upon any assessment of demeanour. Then on the second appeal to this court, the point was taken up, as my lady says, as it were, against the FTT judge, that she hadn't, because of the delay, taken account of demeanour. And that is what led Lord Justice Leggett to say that if demeanour takes you anywhere, it only takes you so far.
Yes.
Is that the sort of
That's
sequence
right.
of events? And as my lady says, that was in a siding of the case based on a response, quite a full response, to a point that the appellant did not have permission to argue.
Yes, that I must accept. Notwithstanding that helpful observation, the position is, we submit, entirely apposite to these sorts of cases. That is, where a judge is listening to allegations which, by their nature, take place in private and quite possibly without corroborative evidence. There must be a robust and thoroughgoing assessment of such issues as can be grappled with that go beyond mere demeanour. So in assessing credibility, it is nonetheless, we submit, essential that a fact-finding judge looks to the questions of inconsistencies, the realistic or exaggerated nature of the allegations, treatment of corroboration, and the absence of any prior complaints. Those are all, I suggest, meat and drink to a fact-finding inquiry. They may assist the court, they may not, but the court has to undertake that robust analysis. I'll start then, if I may, with inconsistencies, and I'd like to identify 4 passages within the judgment which I suggest are fundamental to the judgment and form the foundations of the learned judge's determinations of the facts arising from the oral evidence. The first of these appears in the judgment at A145, and it's paragraph 346. And the learned judge said that, and here she's talking about the second and the third child, each of their accounts is corroborated by the other. Now, that, we submit, is simply wrong. And the starting point must be the evidence of the third child. And the third child and her description of what took place is wholly inconsistent with the evidence given by the second child, both in writing but also orally. For example, in relation to that evidence, the third child told the court that the abuse had taken place between the ages of 7 and 12, and so hadn't taken place for about 3 years. She described it as occurring, and it was pleaded and found as having occurred on more than 5 occasions. But it was that, I can use the phrase ballpark, in which the allegation was set. And she also said that she had spoken to a sister, but child number 1. She only spoke to the first child about the abuse, and this is recorded in the judgment earlier at paragraph 218. She only spoke, this is her oral evidence, she only spoke to the first child about the abuse, and that's wholly inconsistent with the second child's account of being a witness, that is, actually in the room when it happened, and saying that she knew the allegations were true, which is recorded as part of her oral evidence, at paragraph 182. The oral evidence of the second child, in line with her written evidence, by way of a police statement, which is at C688-9, was to the effect that this had taken place 2 to 3 nights a week at about 10 p.m. That she would routinely go in behind the second appellant because he wanted her to watch. And she describes the use of ointment. In her oral evidence, she clarified that this abuse continued up until the inception of proceedings, so for 3 years longer than had been the original allegation. And she gave the following evidence. Firstly, that the third child didn't respond to the abuse, that sometimes she was awake and sometimes she was asleep, and that on occasions the second appellant she would ask the second appellant to stop, but would ask if she could do it instead. And as I say, that it continued up until the inception of proceedings. So therefore, her account is wholly inconsistency in relation to the duration, out by 3 years, the frequency, 2 to 3 times a week as opposed to about 5 times, her presence, and the use of ointment.
Is all of that inconsistency, or is it better described as difference?
Well, I would suggest it's wholly inconsistent.
It depends what one's considering corroboration to apply to. If one is globally considering it to apply to the question of whether sexual abuse was taking place, one might take the view that it was in fact corroborative. The accounts are different, and I take it from you that they're different in the ways that you have described at the moment. But we had a situation here, didn't we, where the 3 young persons gave evidence in sequence.
Yes.
And so when you're referring to what child 3 said, because she was the maker of the original allegations, one has to bear in mind that child 3 gave evidence before child 2, no doubt because that was the sequence chronologically in which the case began, and that nobody asked for child 3 to come back and give evidence after child 2 had made her further statements. So I'm wondering whether it's actually factually correct for you to describe these as inconsistencies rather than as differences.
In relation to this particular point, of course, we had the witness statement in advance. So the oral evidence took it further in the way I've described, but the significant inconsistencies were there on the face of the evidence before either child spoke.
But the witness statement of May 2020 had child 2 speaking about the father having sexually abused child 3. Did it not?
Yes.
Yes.
Yes. So, I mean, that of course, I mean, for example, we have allegation 5, which is the allegation that child 2 was, that there were sexual relations between her and the second appellant. And we don't appeal that because there was corroboration for that. And if I had the time, and I don't suggest that I do this, but the process that one can go through in relation to all the other allegations that we don't challenge, they do have quite significant corroboration. But when it comes to those matters which are wholly without corroboration, and those are all the matters highlighted in yellow, that they are wholly without, they're out of the blue, they are specific and they are quite grave in their terms. They have no direct reflection beyond, for example, what's in allegation 5, that there was some sexual relationship between child 2 and appellant 2. And so, of course, there's a degree of overlap, but in a way, the way I might put it is that the mother, facing these allegations, and indeed on the judge's findings that we don't challenge, was in choppy waters. But the evidence given by child 2 was a tsunami that overtook.
Well, the findings that you don't challenge are extremely serious findings against your client.
Yes.
Regardless of the ones that she challenges.
Yes.
I mean, I noted that you referred to some of the incidents, and I know you didn't mean this in a dismissive way as relatively minor. The word relatively can only really apply when one considers the extreme gravity of the later allegations. The ones that you don't challenge are extremely serious allegations found to be true of sexual abuse.
My lord, of course. And
so I wonder whether choppy waters isn't just like understatement.
Well, I would still adhere to the tsunami reference, because whatever the state of play on the waters, they were nothing like the state of play.
No, except that it's a step above, and particularly the finding that your client participated in and was complicit in all of this.
Yes. And of course, and I know my lord is aware that many, and we'll come on to this if I may in due course, but the expert witnesses were instructed, and at least 2 of them, certainly the psychologist, reported taking into account the fact that the court may well make the findings as they were then pleaded. And still there was whether it be termed a chink or a wider piece of light, there was some light available to the mother.
You say you had a case to argue which you may have been deprived of by the further findings.
Yes, it's a wholly different case.
Having diverted you in this way, could I just ask you about the progress of the proceedings generally, and in particular about one order that the judge made, which was that time to appeal was to run from the provision of the transcript?
Yes.
I think probably the experience of this case, if not others, tells us that was probably a mistake, because you didn't get the transcript until the middle of June or something like that.
No. Well, it took a long time, but I think it's right to say the judgment was delivered over hours. I think it was 7 or 8. It's about 7 or 8 hours in the delivery on a video link, in relation to very difficult matters for those who are taking notes at the other end of the link, surrounded by their respective clients. And
was anybody in court for the judgment?
I may have just checked.
That's when she gave us 2 weeks.
Yeah, between them, excuse me, the parties asked for, because it would appear the judge had notes from which she was reading, whether she would provide those notes. And it was at that point the learned judge volunteered the direction she ultimately made.
But I mean, I think we're probably planning to say, unless you deter us from doing so, that judges shouldn't make times for appealing conditional upon the provision of transcripts, because I mean, here we have a situation where effectively the matter was frozen for 3 or 4 months, simply because of the administrative unavailability of a transcript, whereas no doubt with this force of legal teams, it would have been possible to provide something of a note of the judgment to enable an application for permission to be able to at least have been considered, whether it could have been fully considered or not. So it would be better, would it not, for PTA time limits not to be linked to random things such as when a transcript can be provided.
Well, certainly I can't disagree with that. But I would simply, I think, in deference to no doubt the thoughts behind it, the judge might not have known of the delay or envisaged that level of delay.
Sorry,
The judge might not have known of the level of likely delay.
no, she thought it was going to be available by May because the local authority was to provide it by the middle of May or something of that sort.
Yeah.
But even that's an 8-week delay, and we're dealing here with some quite young children. So
Yes, no, I accept all of that, and I
well,
suppose
where have we got to then as a result? Now we are here today.
Yes.
What's the next hearing?
Shortly to
Monday.
yeah, Monday, my lord.
Right.
Excuse me.
So that's the 20th, and that's a case management hearing or before the same judge?
Yes, before the trial judgment.
Thank you.
Yes, I suppose just this, of course, isn't part of my appeal, but as my lord's asked, I suppose there would be occasions when orders are made, for example, under 9114, where it's envisaged there would be no further applications in a case for 3 years. So it might be helpful to have the transcript, and it wouldn't be a case where there'd be any real delay if one was arguing it should have been 1 or 2 years. But generally speaking, of course, I agree with my lord, respectfully. So how did the learned judge deal with this particular inconsistency? Well, at 368 in the judgment, she, which is page 148, she asks that question. She answers it. This is in the passage dealing with whether the accounts given by second child are unrealistic and exaggerated. And the second sentence is to the effect, well, I've believed everything else she said, so I can't see a reason not to accept this. And with respect to that, I suggest the wrong way around. But she goes on to say, I note that appellant 2 went into child 3's room 2 to 3 times a week, according to child 2, which is not something that child 3 said. Well, that's just one example of many significant inconsistencies. But she goes on to say, I note that on occasions child 3 was asleep and would have been unaware. It seems to me in those circumstances, unlike child 2 who was present, unable to observe. So the first point is there were numerous inconsistencies: frequency, chronology, presence of the other child or absence. This only appears to address frequency. And therefore the other inconsistencies are simply not addressed, nor could they be by this explanation. Secondly, it wasn't child 2's case that child 3 was always sleeping, nor indeed does the judge say that at this part. She indeed, in her statement, didn't mention, as might have been significant, that child 3 was sleeping, and she mentioned it as occurring sometimes only in her oral evidence. And we say it cannot possibly explain the inconsistency that, for example, child 3 alleges that it happened to her about 5 times in total. And also, of course, it would mean that in the additional 3 years that child 2 is alleging this abuse continued, child 3 would have been asleep and unaware of the abuse, and so could not have complained about it. Which is not credible. And if it's an attempt to explain child 3 referring to the abuse ceasing earlier, then we simply say that could not be a credible explanation, because it would have carried on for 3 years without her knowing about it.
369 is also part of this reasoning, is it not?
Yes, it is. Now that I think I alluded to earlier. And that's entirely acceptable, as it were, shift in an allegation that might have been at its inception every day, or certainly from the witness box every day, but clearly was not to be taken literally. Now, that's not a point we take, but the point we do take is in relation to the more greater inconsistencies. On this point, the next matter the judge, I believe it's right to say, does not address at all, is that child 2 told the independent social worker that she did not know about the abuse of child 3. And when she's asked about it and challenged about it in evidence, we have the note of what she said in the judgment at paragraph 201 at A124.
Well, I'm finding that. Take it from your the way in which you've put your case in writing, that the issue here is what the judge did with the evidence, that you're content that we should approach the matter on the basis that her very protracted description of each significant witness's evidence is a reasonable summary for our purposes.
Absolutely. I think there are one or two. So I think I've mentioned that child 2 said that the abuse of child 3 stopped at the inception of the proceedings. I'm not sure that's in here. Right. Maybe, but otherwise.
But for working purposes,
absolutely.
The judge has put all the relevant material in.
Yes.
So did you say 201?
I did, my lord. Yes,
Yes,
at A124. Now, this is the independent social worker, of course, wasn't called to give evidence. And so, evidentially, it stands as an unchallenged piece of evidence before the judge. So she had to take that into account and had to do something with that. She had to give it some weight and weigh that against what the child had said. And she also, I suggest, had to deal with what the child said when the child was pressed about it. And what is the child to make of the fact that she said she didn't agree, that's what she said, when it's clearly recorded and that recording is unchallenged. And she goes on to say, I'm not sure who that woman is, when it must have been obvious who that woman was because she interviewed her. And she interviewed her not that long ago. And I don't think there's been any suggestion that she could not have known who she was. And so it's not just the discrepancy, although that is significant. It's what the child says when asked about it, and then what the judge does with that information. The second inconsistency I'd like to address then is that...
Would have been 16 when interviewed by the ISW?
The second child?
Yes. I'm just supposing that is about how old she would have been.
I think she was 17, Lord.
Yeah, she's 17.
17. Yes.
17.
Thank you, yes.
Now, you told us that there were 4 fundamental passages. Is this one of them?
Yes,
or is it the first?
I'm afraid that's just one, yes.
Are we still on the first one?
I've just finished the first one.
Fine. Thank you.
The second one is at paragraph 374, A149. And it's this is the passage in the judgment, which is the I think where she says child 2 and child 3's allegations are corroborated by what child 1 and child 4 freely volunteered to the professionals. Now we say that is again simply incorrect in respect of child 2. So again, because of the way in which this appeal is framed, we of course accept that there was corroboration for child 3 from child 1 and child 4. And we certainly, I think we would accept that there was therefore some corroboration with what forms a part of allegation 5, that is the sexual relationship between child 2 and the second appellant. But it's not corroboration for the far more serious allegations. And there are significant matters which stand in the way of a judge being able to say that the allegations are corroborated. And what we say first and foremost is that that is an unhelpful statement. It's a broad statement. And in a case where the judge has been good enough to descend into 80 pages of judgment, there was certainly time and space within that judgment to identify precisely what is meant by corroboration. And to take that broad brush approach, we say is not permissible. So none of these matters which were new in oral evidence, as my Lord has alluded to, were put for obvious reasons. But what that means is that that evidence, original evidence, which came before the second child's evidence, pointed away rather than towards the truth of the second child's evidence.
Could you just help with looking at findings 5 and 6 alongside each other?
Yes.
And explain what you make of, what you say were to make of them. Just pausing on the first line of paragraph 5 and the first sentence of paragraph 6. Can you help as to why you object to 6 but not to 5? Or putting it the other way, how, having accepted 5, you can object to 6?
So the objection in relation to 6 is there's a number of reasons. Firstly, there's the regularity, which chimes with 7, and one of our submissions and one of the mother's submissions at trial was that the regularity that's pleaded at 6 could not have gone unnoticed by other family members, and there was direct evidence from for example, the maternal grandmother, who was no friend of the mother's, that she had witnessed no such abuse. There's no evidence from any of the other children that there was a regularity. There is some evidence of a sexual association. And the second sentence, of course, provides a direct allegation of blackmail.
But leave that aside and leave the things found in the bedroom aside, although they might be something of a straw in the wind. We can look at C10, C11, and C14 in a moment, but those are from which statement?
The social worker statement.
So those are based upon statements made by?
Made by, I think 4 children, 4 eldest children, because I think the 4th, because child 4 is referred to. I'm not sure about the pagination.
Well, we can look at that in a moment, but
yeah,
I mean, in some ways, it might seem that for a stepfather to be having sex with an underage stepchild, that's accepted, at least on your client's part, that we're spending quite a lot of time working out how often he did it. I appreciate that might have ramifications for your client's state of knowledge, but is that what this is really about?
No. My Lord, the thinking behind the highlighting is that all of these matters that are highlighted came out in oral evidence. Now, I accept.
I know intellectually how you cut it, as it were.
But I don't disagree, my lord, that sexual intercourse in this way that's described at paragraph 5 is sexual abuse. Of course. I think that it's really the intellectual consistency in challenging the oral evidence and the judge's treatment of the oral evidence.
But as soon as one accepts that it's happened,
Yeah.
then the probability that it's recurred is immeasurably increased.
But I think that the tenor of 6, which then leads on to 7, is obviously there's an uneven nature in the relationship and there's an abuse of trust, but there's an express allegation of threat, of blackmail, and then there are express allegations of threats and pushing and shoving and the rest of it at number 7. So it's the introduction of coercion at 6, which is not in 5.
But what difference does coercion make? I mean, it's coercive anyhow.
It is coercive, but for example, in the fact-finding determination that the judge was undertaking, I think at C10 or C11, one of the children is recorded as saying that there may have been an element of jealousy between the mother and the second child, which might point towards some knowledge, but point away to her being complicit in physically encouraging it or take participation in it. In other words, if she's jealous, she's unhappy about it. So I think it's really the introduction. Of course, I accept what Milord says about that the shift from certainly the whole of paragraph 5 and the first part of paragraph 6. And I accept that it is implicitly coercive for a parent, whether it be a step-parent or a natural parent, to undertake this abuse. But for our part, it is an allegation that appeared directly of coercion at the same time as the allegations in paragraph 7, which allege participation coercively by the mother. But I don't think I can take that usefully further.
I can't at the moment understand why your client rushes to the stepfather's defence in relation to how often it happened. I quite understand that she has an interest in arguing whether she knew about it and whether she took part in it. But
well, I think
I don't understand at all why, if it happened, she's trying to minimise the number of times it happened.
Well, my lord, I think that isn't how she puts it. I think how she puts it is that, or at least how I put it on her behalf, is that the judge's treatment of this new evidence given for the first time is capable of criticism, and that therefore those matters which are reflected by that in this schedule should fall away or fall to be more carefully scrutinised by this court. But of course, I think I've conceded that there are many similarities between 5 and 6, but 6, as it were, is a step to 7 and introduces direct coercion. But she, for her part, the way in which I seek to advance the appeal is the judge's treatment of the evidence and the necessary consequences of that, whatever they may be for the schedule. So the allegation that's advanced in oral evidence by child 2, which this has been taking place since she was 12, and so dealing with that paragraph 6, in fact, she shared a bedroom with child 1 until 2017, 2018. So for the first 2 or 3 years, the basis for her assertion is that this went on unnoticed by the person she shared a bedroom with. And so that was advanced in written submissions on behalf of the mother at paragraph 65 of those written submissions. And that is not addressed by the learned judge. And it's clearly a relevant factor when considering when the abuse started. So the third inconsistency is at paragraph 390, which is A151. Where the learned judge says, it's right at the bottom of the page, such inconsistencies as there are in their evidence are relatively minor in the scheme of things, particularly when compared to the more material inconsistencies and contradictions in the evidence of the appellants. So we certainly take issue with the suggestion that the inconsistencies were relatively minor as between, and this is here talking about child 1 and child 2. The first obvious one is that in her evidence, which is recorded at paragraph 147, child 2 is said to have told child 1 in 2016 about masturbating the second appellant. She called giving him a hand job. Child 1, according to child 2, told child 2 to tell the police. Now, that was never evidence given by child 1. Of course, she wasn't recalled. But what it means is that the judge then has to deal with that. And what she cannot do, in our submission, is say, well, these are relatively minor inconsistencies. They're fundamental differences. She records a further inconsistency.
The sequence of witnesses was child 3, child 1, child 2, was it?
I think that's right, yes.
Yes. And child 1's evidence was that she didn't like the father, but she acquitted him of any misbehaviour.
Yes. She had made an allegation on the 10th of February to a social worker. She accepted she'd made that allegation, that he'd tried to kiss her. But that allegation was thereafter retracted and never repeated.
But she also said that she knew that he was involved in a sexual relationship with.
Yes.
I can't remember which of the other two girls.
Child 2.
Child 2.
Yeah, so that's so clear. That's why I accept there's clear corroboration for allegation number 5. The evidence given by the two children is earlier summarised at 185 to 186 at A121. So one can see there's the reference at 185, the child 2, and this is halfway through that paragraph. She said she told child 1 about the abuse, and so child 1 knew about it from 2016. I share everything with my sister. And then she said this. She said that child 1 responded by saying, "Don't worry, we will leave the house soon." And subsequently, the learned judge does in fact find that there had been such a discussion. That's based wholly on the evidence in child 2 and is wholly contrary to the evidence of child 1. And then the next paragraph, child 1 also gave her advice about the police, but she said she felt she couldn't do that because she was being blackmailed. So here, the advice she alleged she'd received from child 1 is inextricably linked to her allegation of blackmail. So she's caught, isn't she, by saying, if it's not true, that she told someone, and someone told her to tell the police. So she's got to explain why she didn't tell the police. And that underlines the allegation of blackmail. So I don't think any party considered it would be appropriate from their respective positions to advance an argument that child 1 or child 3 should be recalled. I think all the parties accepted that the judge had to do the best she could in the light of the evidence that she had received. But what that means is certainly grappling with the issue and certainly not saying that such inconsistencies as there are relatively minor. So she really had three options, did she not? She could have decided to recall children 1 or 3. She could have accepted what child 1 said because it was unchallenged, or she could have just tried to make the best of it in the circumstances, and we say she did none. There's then the reference, and this comes from the police statement, to the account of the second appellant trying to kiss child 1, the account given by the second child of that. And we've got, as it happens on the next page, we have that account, 187. And so we can see that there's a discrepancy in year, which, given the ages of the children, 3 years might be considered significant. The local authority in their schedule write both. They say in or around 2014 to 2017. But importantly, the allegation is that this child was pulled up the stairs. She says the mother was present. And if we're dealing with a kissing incident, the description given by child 1 is that it took place in the kitchen and nobody else was present. She did say, child 1 did say in oral evidence that she was pulled up the stairs, but she did not assert that this by her hair, but this was not a sexual act. And child 2, to the police, did refer to an account of, and this is, I think might be helpful just to look at that, sorry, that's the old pagination. So it's C688. And there she's talking at the foot. Sorry? PDF 907.
Thank you.
At the bottom of that page, again it's 2014. And significantly, she's not a witness. What she describes is, in the second line, I was not there at the time, but child 1 told me how.
I follow that, but where's this going? Is the kiss on child 1 one of the findings that you challenge?
No, we don't challenge that finding.
No, I didn't think so.
But what we do challenge, however.
So what's it matter how many people saw it?
Well, what we do challenge is what child 2 said about it and other matters, and the judge's assertion that this lends consistency to her account, when in fact her account is quite inconsistent for the reasons I've set out. This is about the judge's treatment of her evidence, and in particular her direct assertion that there is a consistency where there is significant inconsistency.
So the picture is that the stepfather did make a sexual advance to child 1, that child 2 initially did not give an account of seeing that happen, rather being told about it, that she later gave an account of having seen it happening, and that's the inconsistency.
She gave an account of having seen it happen in quite different circumstances to that which was the basis of the allegation found by the judge. The basis of the allegation found by the judge is what must be what child 1 said about it. And child 1 said it took place in the absence of anyone else, in the kitchen. It was not accompanied by pulling of hair,
which happened on another occasion.
which happened on another occasion.
All right.
And it's
The judge, you say, should have taken that as damaging the credibility of child 2,
yes,
that she gave 2 different accounts in relation to this matter, one in May last year and one in January this year.
my lord, yes, and that they're significant inconsistencies. It also follows, and I'm still dealing with the judge's assertion that the inconsistencies between these 2 sisters are relatively minor. Sister 1, so the oldest child, told the person who conducted the viability assessment of her, and this is at C331, that the second child got on very well. So far from being scared of or under the cosh, as it were, from the stepfather, got on very well with him. And she went on in her oral evidence, and this is recorded at 170, the first child, say she didn't know of any of the matters that subsequently, the gist of her evidence at 170, obviously in advance of the second child giving evidence, indicates that she knew nothing of what the child 2 then went on to say. Then at 3, still on the same point, but develop it, 395 in the judgment, page 152. She refers to the atmosphere created by the stepfather, but enabled and facilitated by the mother, and that it was such that these young girls experienced fear, and they were isolated, even from each other, but certainly wider members of their family and community. Now, given that 5 paragraphs before this, at 390, the judge had said, in relation to both child 1 and 2, but here I'm concerned with child 1, that she was recounting her own genuine lived experience to the effect, as she had told the parenting assessor, that life at home, family life, was fantastic. How does she square that account of family life with her finding at 395 that the children lived in fear as a consequence of their mother and stepfather's behaviour?
I haven't understood that point. I follow what you say about 395. What's the contrasting or inconsistent account?
So child 1 gave evidence that family life, this is at C328, was fantastic.
I'm sorry, you're not in the judgment at this point.
No.
So child 1 says it's fantastic. The judge finds that it's appalling.
Yeah.
What's the point that arises from that?
Well, the first point is that she's just said 5 paragraphs before that she accepted what the child was saying to her was her genuine lived experience. And part of her evidence to the court was that family life was great. There was nothing to worry about. Things were good. Her sisters, and certainly child 2, there's nothing to suggest to her was living in fear. Or
Right. Is she correctly referring to child 1 and child 2 there, or is she maybe referring to child 3 and child 2? I'm not suggesting that she's made an error, but this is...
Yeah, I wondered about that, but then...
This is in a passage when she's surveying the evidence of child 1.
Yeah, it's throughout, it's child 1.
Yes.
I think, in fact, that's what she means. But in any
Because
event...
she's just found that the mother and child 1 are, from the mother's perspective, in collusion.
Well, yes, but this is the danger of relying on demeanour. But in any event, the primary point is that child 1's evidence to the court was that she did not live in fear. And that's an inconsistency.
Well, she's in the sequence that you're referring to. She's just said that she prefers the original account of child 1 to the retraction. And so it's difficult to understand what she means at paragraph 390, as you say, by saying when they gave evidence, referring to childs 1 and 2. The flashes of resolve and defiance when challenged would seem to more appropriately apply to childs 2 and 3, who are the children who are making the allegations, not those, the one who'd withdrawn them.
Well, that might be where a logical take, but every previous paragraph on that page, well, nearly every previous, refers to child 1.
Well, it's the elbow between child 1 and going on to deal with child 2, isn't it? Because from 390 onwards, 392, etc., she's dealing with children 2 and 3 for quite some time. Anyhow, you've
I'm not sure she deals with child 3 until the bottom of 152. But
well, we get by 399, for example. We're back to child 3.
yeah.
All right.
It's fair to say, isn't it, that up to this point, the judge had quite clearly signposted where she was going,
That's right.
and then that rather disappears,
Yes.
and one's left to some extent trying to work out who she's dealing with and what she's dealing with thereafter.
Well, I think that's right. And there are passages later in the judgment which are, at the same time as appear to be a finding, are a commentary on the finding. So there are assertions that this type of abuse, which is then described, is appalling for these reasons. So it's quite clear that she has found, but it is the difficult judgment to follow when it comes to the reasoning process and where one picks it up and where the analysis is to be found. So, for example, one sees the evidence of the two oldest, children 2 and 3, and the professional witnesses. Their evidence is set out in summary form. When one gets to child number 1, there is, of course, a summary, but there's also a commentary and a critique of that evidence. And then one comes back. So there is a different way. I'm not saying it's impermissible, but it's confusing potentially. Whereas one would prefer, I think, to have a summary of what the evidence was, and then pulling from each of those pieces of evidence, what the court finds. And we submit, I suppose, in a very superficial way that if she had simply gone through the allegations as they were set out and looked at the evidence for each in turn, then it might have given her to understand the inconsistencies which she seems, I suggest, to have forgotten about. So that's why when I'm referring to conclusions in paragraphs 350 odd, I'm going back to findings she's made previously at paragraph 185 odd. Yes, and then just finally on this point, I alluded to it earlier, the passage about leaving home is at paragraph 416. She's satisfied that the two girls had conversations about leaving home. Of course, that's only the evidence of one of those girls. Clearly an important matter, because that could corroborate. But what was the evidence in support of this? There was none, apart from the account, solely the account of the second child. It wasn't the first child's case. And she never said that they had conversations about that. In fact, between them, and it's alluded to elsewhere in the judgment, the bond was greater between child 1 and 3, and child 2 was seen as slightly out of that. I'll move on then to the final inconsistency, if I can, which ties in with a later ground, which is paragraph 367 at 148. here she is talking about and taking together the main, the children making the main allegations, children 2 and 3. And here she's dealing with what might be described as such inconsistency, she says, as there were. So just pausing there, in our submission, it's incumbent upon the trial judge undertaking a fact-finding inquiry to make it clear what she's talking about, so the person reading the judgment can understand. So here, when she says such inconsistencies as there were, she should, in our submission, have set those out. What were the inconsistencies that she was alive to? And why is it that she can deal with them as she then proceeds to deal with them? And what, in fact, 367 is an answer to the inconsistencies based upon judicial notice. So she says,
there was a period allowed for clarifications following receipt of the transcript, wasn't there?
yes,
So I'm sure it'll be said that that if you wanted more on 367, the judge could have been asked to provide it.
but if that is said, of course, we then, by that point, there was an imperative to issue the appeal because the time was running from receipt of the transcript. I suppose more time could have been requested, but
No, but everybody was sitting there taking notes, and if this point was one, it could have been asked at any time.
well, I'd suggest that if that is a fair point, then that yields to me the following submission, which is that one must take it as encompassing, without further particularity, such inconsistencies as, whatever they were, the judge saw.
Yeah.
And if that's right, then her answer to the inconsistencies was judicial notice of certain facts. And the judicial notice she takes, and judicial notice is, as my lords, my lady appreciate, is the establishing of a fact without proof. The judge takes notice of the fact. So she took notice of the likelihood of there being a significant emotional and psychological impact on each of these children, and that they had suffered in silence for so long, and they'd had no counselling, and while the children had flashbacks.
Could I take you back to 390? I know you've moved on from that. And the question about which of the children were being addressed here. I have some difficulty in reconciling 390 with 342.
Yes. Well, they are irreconcilable, at least on that part of her evidence. So my reading of 390 is that apart from that, the judge is finding the child to be as she described. That's the only way, I think, in which one can... I think what she's saying is that the children were doing... those two children were doing their best and were recounting their genuine lived experiences. But there is a clear inconsistency, yes.
The other explanation is that there, as my lord suggested, she has confused first and third child.
Yes. And suppose if that were right, and if that were to be the inference to be drawn, then the submissions I've made about the significant differences in the accounts, particularly about the third child's, as she says, genuine lived experience of what she had suffered at the hands of the stepfather, wholly different. They can't both be recounting their own genuinely lived experiences with such inconsistency. So, may I return then to paragraph 367? I think what we'd say is it's a circular argument. In order for her to take judicial notice of the effect of the abuse, and the judicial notice is the establishing of a relevant fact to lead her to make a finding or not. The finding or not is, were they sexually abused? And the fact that she establishes without proof is dependent upon them having been abused. So they could only have this psychological impact, it could only be relevant, and it could only be found by way of judicial notice if they had in fact been abused. So
where does this take you as your appeal proceeds on the basis that they had been abused? Why are you making this point? Where does it get you?
Well, it's the point about it, my lord, is that this is her answer to the inconsistencies, and it's not a permissible answer. The answer to the inconsistencies is to list them and address them one by one in the way that I've sought to do, and the way that the learned judge in my submission didn't do.
But are you saying that the specialist family court judge is not entitled to take account of the fact that sexual abuse and other forms of abuse have severe effects on the well-being and functioning of the victim?
No, she's entitled to take notice of that, but what she's not entitled to do is to take judicial notice of the effect of that on a particular person without proof or without evidence. That is not judicial notice. It's judicial notice that there is a range of responses, generally negative.
And I wasn't suggesting, the judge mentioned judicial notice 6 times in this judgment, and you focus on 2 of them.
Yes.
I don't think she's actually taking judicial notice of anything, actually, properly so called.
I've taken her at her word, but
exactly.
I understand.
Yes, but I think the other way of looking at it is she's simply dressing up something that any family court judge knows, because it's the environment in which the public law family court has, unfortunately, to work.
These submissions are intended to encompass 3 of the 4 grounds. I'll deal with res judicata separately at the end, if I may.
Yeah.
But of course, if it were the judicial notice point, I wouldn't be here. But it is important to, in that it is the answer to the inconsistencies, and it's not a permissible answer to the inconsistencies.
Yes,
However,
if it's the only answer to the inconsistencies, I understand your point. Yes. It's circular.
So, my lord, then unrealistic and exaggerated. She addresses that expressly at same page as it happens, 368. I think we've looked at this paragraph before. While Neymer's evidence may be considered to be unrealistic and exaggerated in terms of daily physical and sexual abuse, on the balance of probabilities, I'm inclined to believe her and to accept her evidence. Again, if she is to do this, it would be helpful, although I appreciate she wasn't asked to set it out, to identify what it is she considered to be unrealistic and exaggerated. But I take it, without particularisation, that she's dealing with pretty much all of the material that came for the first time from the witness box, from the second child. And this is therefore the point at which, in the judgment, she should have engaged with the submissions, advanced on behalf of the mother. And they're in the written submissions, and my friend Miss Littlewood, that I can ask my lord, my lady, to look at C164. where in one paragraph a number of submissions are made about the evidence given by the second child. This is paragraph 68, running from little a to little l. And in particular, when it comes to the issue of lack of realism or exaggeration, subparagraphs D, E, G, K, and L are all relevant. And in assessing the credibility of the complainant child, it was incumbent, we say, upon the learned judge to address matters that she herself described as potentially unrealistic or exaggerated. Because there's actually, that I summarise, but I think it's been said that one would expect from a judgment. I think this court has said that the judge engages with the respondent's best points. And there are many, I suggest, good points in this document, but certainly paragraph 68 sets out a number of points. I've just identified those that go to unrealistic and exaggerated. But none of them are addressed by the learned judge in her judgment. The second point on this issue is then what the judge says at just a little earlier in the judgment at 350. Sorry, it's the previous paragraph. It's the final sentence of the previous paragraph, referring to child 3 and 2. They each had a number of opportunities to embellish their evidence, but they chose not to. Certainly accept that in relation to child 3. But of course our submission is that the oral evidence, the nature of it, and the nature of the allegations was precisely of child 2, an embellishment, huge embellishment. And one goes on then, I think, at 350, to say that the learned judge says at the start of that paragraph, there did not appear to be any particular malice demonstrated by them towards the stepfather or the mother. Beyond second child saying that she hated her mother now. And of course, it's the allegations made from the witness box that are so damaging, so gravely damaging against the background of damaging allegations anyway. So to say that there didn't appear to be any particular malice, and then to follow that with the recitation of the child saying she hated her mother is rather contradictory. So therefore, when looking at inconsistencies, exaggerations in our submission, there was the judgment is flawed. I go on to deal with now with corroboration.
Can I just ask you why on that page, and forgive me for coming back to the structure of this, but I've been trying to work it out. Paragraph 351 says, I'll now set out my reasons for accepting the evidence of second and third and second child, referring it to that of the mother and stepfather, and also first child and grandmother. Now I understand that, as it were, prefaces the rest of the judgment. And that is what the judge is engaged in for the remaining 180 odd paragraphs. Is that how you understand it?
I think that's how she intended to deal with it. I'm not sure that that's how she does deal with it.
And as I understand it, the reference at 375 to addressing the evidence of the first child is, as it were, an interlude in that overall exercise.
Yes, exactly. So that's the first time at which the first child's evidence is addressed in substance.
Yes, thank you.
So that is a matter that is difficult, I suggest. We addressed the question of corroboration in our skeleton argument at paragraphs 27 to 31, A23. Now, just whether we address them there or elsewhere, can I just run through, as it were, 5 or 6 matters of on issues of corroboration, which the judge says amount to corroboration, but in summary we say really did not take the matter very much further. And the first is that the stepfather had the opportunity, and that's at 353 A146. He clearly did have the opportunity. He also he was in the house in or living in or around the house at the times when the children complained that they were abused respectively by him.
And when he claimed he wasn't there.
I'm sorry?
And when he claimed he wasn't there.
Well, I think, yes, I think that's right, but...
the judge found he tried to distance himself
yes.
from the home, and she considered why he might have tried to do that.
Yes. So I'm accepting what the judge says about that. What I'm saying is that that didn't really take matters very much further. He was clearly in the house. He had the opportunity. The next matter relates to the use of chilies. In this house, a Naga chili, I suggest, and the judge would have known, was as common, I don't know, as a pot of jam or mustard. So the fact that this house had a Naga chili did not lend any particular corroboration to the allegation that it had been improperly used.
No, but the fact that such an allegation was made is so striking that either it is a flat lie or it's true. It's not one of those allegations that could be mistaken.
No, exactly. But the fact, I think it's at 354. Talking about a credible factual matrix. And she says, I note, for example, in relation to the Naga chili incident, the mother confirmed they did indeed have those chilies in the home.
Well, you say that's like saying that if somebody says that they were hit by a belt, the fact that there was a belt in the house
Yes.
is corroboration.
Yes, right. Just a common item in that particular home. So that doesn't...
In that paragraph, she's doing no more than considering whether the allegations correlate, as she puts it, with a credible factual matrix.
Yes, well, I think well, it's credible in that she didn't say that she...
Yes, but apart from the sentence that ends paragraph 354, which must be one of several thousand sentences in the judgment, is any other weight placed on that?
No. I'm simply running through a list of matters that appear to be corroborative.
And I could understand if the judge said, I find it a matter of intense significance that there were these particular chilies in the house. One might raise an eyebrow.
Well, it's the previous paragraph, 353, is, in fact, 352, she begins by saying, and this is just after why she's preferring their evidence, in effect, they're internally consistent and credible. Sorry, they're internally consistent and credible when considered against external factors. So this is where she's dealing with corroboration. And she deals with internal matters at 352. At 353, she begins to deal with external factors. So she is at 354 setting something out which her introduction at 352 tells us she considers provides consistency and credibility. And in our submission, it didn't do that. And adds nothing. And similarly then at 355, the ring of truth about the burning sensation in relation to the chili incident. Well, again, someone who is familiar with, let us say, a strong mustard might have tasted it and sensed a burning sensation. Doesn't add credibility or consistency that this child said that she sustained a burning sensation in the way she described. And then she goes on to say that the way in which the doors opened with a key from the outside was something which supports the child's account. This is a paragraph that begins with the child's account having flowed freely and giving dense contextual detail. So she is clearly here relying upon these external factors as supportive of that child's account. And there is nothing supportive in being able to tell a judge how a door opens in your house, where in the house a storeroom is to be found, or what in the storeroom is stored. So I don't see that any of these matters really take the matter any further. And this is we say, the learned judge's opportunity to deal with what she describes as external factors lending credibility and consistency to the allegations. And really, we say she didn't identify anything of substance. She deals with another issue at 407, which is that the child left home. It's at 154. She says that child 2 has not retracted the allegation she made to the police in her statement, and she too has voted with her feet and left her mother's home to reside with her grandmother. All of these facts, and not that she doesn't speak to her, all these facts support the conclusion that she's telling the truth. She had left home well before she made her witness statement to the police, and her witness statement to the police makes no mention of the matters she raised in evidence. And so it's hard to see that leaving home adds to the credibility.
Well, the fact that two teenagers each separately decide to leave home is surely something that the judge is entitled to weigh up as part of the overall picture. Is it not?
Well, she can weigh it up. She ought to weigh it up by a fair reference to how they came to leave the home. So in part, she has to note that this particular child didn't initially want to go into foster care.
No, but she preferred to go for a couple of days to a friend before going to her grandmother. I mean, surely in the big picture of things, for your children to prefer to be somewhere else other than in the family home is a circumstance that requires some thought by a judge deciding what might have happened in the family home.
Yes.
And the options in this case were either that the children were responding to mistreatment in the family home, or that they'd been put up to it by the grandmother and father one.
Well,
and that was a possibility that the judge considered and rejected.
Well, this child has been mistreated by dint of allegation 5.
Well, not according to your husband.
No. Well, I don't think. No, but I think she said that wasn't our case there at the trial. It wasn't her case at trial. Was not that this hadn't happened. But certainly on this appeal, and we accept that finding stands.
But your client's case on trial was that nothing at all had been done. She
didn't know. Her account to experts.
She contested all the allegations in a variety of ways, as I understand it, which included denial, not prepared to deal with it, didn't know, but she didn't accept a single one of the allegations except the one that she wanted to make against Father One.
Yeah, so well, she did that. I think that's fair. She didn't accept any of the allegations. That's fair. But she, I think, her best case was that she was open to the possibility. The worst case was that she wasn't open to the possibility because she didn't see anything, but it was somewhere in between.
Anyhow, you say that 407 was something the judge wasn't entitled to have regard to.
Well, in relation to the more serious allegations, it cannot in the case be corroboration of the more serious allegations when we accept allegation 5, for example. If I move then to the lack of prior complaint by the second child in relation to matters given in evidence. And we deal with this at paragraph 25 of our skeleton at A22. And that is the initial inconsistency that when asked on the 10th of February about it, she denied any abuse. And what we go on to say is and then the judge found as a fact that this inconsistency was caused by the stepfather and mother telling her to lie. And so, again, we say it's a circular argument, because the judge is asking herself, is this an inconsistency, the lack of complaint on the 10th of February, a matter which helps me to understand her later allegations to be less credible or not? And her answer to that question is no. It doesn't help me because she was told to lie. What is the evidence that she was told to lie? It's the fact that the allegations are true. Because the only evidence that she was told to lie by the mother or the stepfather, because all the other professionals said there was no clear way in which they knew from their knowledge the parents knew about these allegations. The only way they might have known, the judge says in her judgment, was because they're guilty of the acts complained of, so they knew what was coming. So that's an argument, that's a circular argument. She's asking herself, can I rely on this as an inconsistency in assisting me? No, because she was told to lie. Where's the evidence she was told to lie? It comes from the fact that her parents knew what had happened and the allegations are true. So that, in our submission, is not a fair way to deal with that piece of evidence. In relation to the police statement, the judge deals with that at 372 A149. And what she does is speculate, I suggest, in the second part of the paragraph, that having taken the step of saying what she did in the police interview, she then found the courage to elaborate upon the allegations and make the further one she did at the hearing for the first time. And then she says this, which we say is curious and not something that can be supported. It does not undermine her credibility. Rather, in my judgment, it serves to enhance it. It's hard to see, we submit, how there could be any justification in the learned judge saying that a previous inconsistent statement, even if there's an explanation for it, positively enhances the subsequent statement. And where is the analysis by a particular reference to the statement? The police statement itself does demonstrate that these were allegations to the police of sexual advances and sexual assault of both her and her sister. The learned judge needs, in our submission, to ask herself the question, why was it that she felt able to do that then, but not able to do that now, not able to give the full account, even though she addressed matters of a sexual nature against herself and her sister. And then she contrasts it. This is where she deals with judicial notice, and she goes on to say that this wasn't a polished, rehearsed set of allegations. Well, that's not the only alternative. One doesn't just have, on one side, a polished set of rehearsed allegations, on the other side, wholly inconsistent allegations. And it is important in relation to the lack of a prior complaint. I've mentioned this earlier in submissions. The piece of evidence recorded at 185, paragraph 185, page A121. This is the evidence about her not saying things to the police on this occasion, that the hand job, the naked photos, and so on. And what she said in answer to that, her explanation in answer to that question, was in part to say she had mentioned it, that this was not the first time, and she had told the oldest child about the abuse in 2016, so she knew about it. So the inconsistency itself I've referred to already, but it's now important when the judge is coming on to consider the lack of a prior complaint, because this is what the child says in answer to that challenge. Why didn't you mention it before? I did mention it before, and that's not consistent with the other child. And that, in our submission, the judge needs to address. And what she simply says at 186 is that the child was not recalled. And then in relation to the photographs, the judge in our submission should ask herself why, if she was worried about publication of photographs, when she made her statement in May, was she not worried about publication of photographs when she gave her evidence in January? And these are questions that arise and need to be answered. Also, in relation to no prior complaint, the judge had evidence that this child had been interviewed by an independent social worker, a culturally appropriate female and independent social worker instructed by the court. And we can see what she said to that worker at C369.
Before we leave the page that we're on at the moment, could we just look at 183, which relates to the point that you were making a moment ago about you said that the judge had effectively made a supposition that the child 2 had been told not to say anything on the day when child 3 made her allegation. Paragraph 183 records what appears to be direct evidence from child 2 that she had been told not to say anything.
Yes, exactly.
So there was evidence that the judge was entitled to accept, might be thought, that she'd been silenced.
Yes, that came from that child. The question is whether the judge was entitled to draw comfort in the way she did.
Well, you said the only evidence that she was told to lie is the judge's explanation that the allegations were true. But that wasn't the only evidence. It was the direct evidence of the child herself that she was told to lie.
Well, my lord, I'm grateful for the correction.
I mean, I'm not taking you to task about it, but
No, I'm grateful. What I mean by that is it's the only evidence of corroboration of what that child was saying. But so I accept that correction.
Okay. Right, you were going on to a completely separate point, sorry.
It was just in relation to what she told the independent social worker. I made the point. So this is 369. If the court wishes to look at the allegation she made, in the comfort of what the judge described as her safe place, which is her grandmother's home. We can see the allegations at the top of C369, 6 bullet points. Some slight embellishment in bullet point 3. Some significant, and I'll come on to bullet point 4 in due course, because that's allegation, I think, number 10, about the physical abuse and the extent of the physical abuse. But there she's beginning to make quite extensive allegations. And then standing outside for 8 hours is said there for the first time. But none of the matters that are otherwise set out in her oral evidence for the first time are addressed there. And the learned judge should, in our submission, there needed to be an analysis within her judgment of why she was satisfied that child 2's account could be believed when she had an appropriate female independent social worker who could speak to her. A point in relation to this was made in the written submissions. It's at C164 by my friend Miss Littlewood. It's 68B. By making allegations in 2016 about physical chastisement, this child showed that she was able to tell professionals about at least physical abuse, even if she was unable to talk about sexual abuse. So the learned judge had to engage, we submit, with that and ask herself whether there was a reason why she felt able to make those allegations in 2016, but if she was suffering what she said she was suffering, she didn't make the greater allegation. And then on this point, this is another judicial notice point, so I might take this quickly. 373A149. This is the passage just below the one I've referred to about her finding the courage, developing the ability to speak and enhancing her credibility. The judge goes on at 373 to take judicial notice of the fact that reaching a position where she's able to articulate and acknowledge, firstly to herself what had happened to her, and then to divulge everything and unburden herself, can take a victim years, and is very often a slow, incremental, lengthy and painful process for a survivor of abuse, such as this child. Now, of course, it's a confused sentence because it starts off by referring to the child, it closes by referring to the child, so we're in those terms. Then in the middle, as we're talking in general terms about victims of abuse. But what she's saying here, where she's in the previous paragraph saying that this child is giving genuine evidence, uninfluenced by others, is that no proof is needed that what was in play for this child was a slow and painful process giving rise to the ability to divulge everything. That's what it means if she's to say that she takes judicial notice of that. That is the fact that she relies upon.
The judge did have evidence from child 2 in relation to the Chile incident that she hadn't spoken to child 1 or to her grandmother about it because it was, quote, way too personal.
Yes.
So there was at least that evidence, and there may be other aspects of the judgment that I haven't alighted upon. In in which the child expressed what one might think was appropriate embarrassment about giving an account about this sort of
Yes.
event. So why is the judge not entitled to take that into account?
But she is entitled to take that into account. But what she can't do is make a finding of fact based on judicial notice that, in her words, this was a slow and painful process, giving rise to an initial inability to divulge everything. That's what it means to say that she's taking judicial notice. She's establishing a fact without proof.
That assertion, recognition, is very similar to the sort of standard direction which judges give to juries about victims of this sort of matter day in, day out. And it's not objectionable on the basis that it's taking judicial notice. It's simply a recognised aspect of the way that these matters sometimes come to light for victims of this type of criminal offence.
Yes, so I couldn't oppose or object to a judge saying that she takes judicial notice of the fact that the effect of abuse can result in the delay of allegations. But here, she's addressing why it was for this woman, young woman, but without further proof, it must have been the abuse that she suffered that has delayed her in coming forward, when it might otherwise be a point that points away from her credibility. So
The first sentence is dealing with what can take a victim years and is often a slow, incremental, lengthy and painful process for a survivor. That's talking in generalities.
yes. Which I say it is slightly confused because it's talking about generalities, but it's also talking about this particular child. And
Well, it's recognising the potential application of the generality to the specific, isn't it?
well, our submission is that it's going further than that. It's going beyond simply saying that this is a possible reason for it. But because it's a judicial notice of the fact that she has reached this position in this way, that's what.
Well, effectively, I think what you're saying is that the judge is assuming that which she seeks to prove by making this general point.
Yes.
I have some difficulty with the idea of lack of prior complaint in the context of sexual abuse. If that was a point of any weight, then people wouldn't be getting sexually abused all the time and for years in the way that we know that they are.
Yeah, of course.
It's a point. Lack of prior complaint seems to me to have absolutely no resonance in the context of allegations of this sort.
Well, I respectfully suggest it must in every case be considered, and it may well be in most cases. That
Well, the judge considered why didn't child 2 or indeed any of the other children make allegations before child 3 made them in February 2020, and that's her explanation.
Well, but the child's explanation, and that's perhaps the much more important point, is when the child is asked about it, she gives an account which is simply not true. And it's about having told her sister in 2016.
And how do we know it's not true?
Well, we say that it doesn't fit with that child's account.
No, but that child's been found not to be a truthful witness, so round we go.
Well, she needs to deal with that in the judgment. She doesn't.
We've said that the whole basis, the basic gist of your appeal, as I understand it, is you say this is a judge who believed the second child as a matter of demeanour, and the judge's approach thereafter was effectively to explain away or dismiss the difficulties rather than to grapple with them and factor them into the prior question of whether or not she was credible.
Lord, that's a better summary than I could muster, but would seek simply to add, and it was incumbent upon her to demonstrate that in her judgment, that she had done that which she has not. So it's incumbent upon her to set out all the inconsistencies and to address them. It's incumbent upon her to set out the exaggerations and to address them, the potential exaggerations. and it's incumbent upon her to address corroboration, which she did, but primarily or predominantly in an impermissible way. She relied upon matters that were not really.
Why is it
I'm sorry?
obligatory to address corroboration? I mean, the presence or absence of corroboration is clearly something to take into account.
Yes.
There's no principle that allegations of this sort have got to be corroborated.
No, but they need to be taken into account, as the Lord says. And so
Yes, but
when
you seem to be suggesting that the absence of corroboration is a factor that undermines an allegation.
No, what I'm saying is that the absence of analysis of that which may or may not corroborate, or rather analysis to suggest that there is corroboration for something where there is not, is a
If that's
flaw in the judgment.
A different point, yes,
Yeah.
I understand that.
Can I think, then just deal with the physical abuse allegation of 10, and then the issue of estoppel point. I'll take the physical abuse point, I hope, briefly. Before the child went into the witness box, so this is allegation 10. Before she went into the witness box, what the judge knew is that she had told the police that child didn't feel safe around the stepfather. This is C689. He would hit me with a stick or anything in his hand every single day. I don't have any injuries. It would hurt at the time. My mum does this as well. If I don't listen to her, she hits me. But that's the allegation to the police. But then to the social worker, the independent social worker in the place of safety, as the judge describes it. Asks her expressly about it. And it's a passage that is developed in the course of the interview of the maternal grandmother at 370.
Is this in the judgment?
My Lord, no, it's not.
What page?
370?
C370.
Please.
Thank you.
Is that paragraph 11.29?
That's it, my lady, yes. Before she speaks in court, the latest account of the mother's physical abuse is that given to the independent, culturally appropriate female social worker in the place of safety, her grandmother's home.
Okay. Just picking up 11.29.
Yes.
The allegation made the day before about being hit by her mother, this is because there were interviews in consecutive days, is that right?
I think that's right. Mr.
Right, so what the independent social worker is saying was that on, let's call it day one, child 2 was saying that the mother and stepfather hit her
Yes.
regularly.
It's on the previous page.
Thank you.
It's the fourth bullet point. I said I'd return to it. I'm grateful my Lord has brought me back.
Right.
So that is said the day before. The very next day she qualifies it by saying, in fact, it was the
So she says at this point being hit with tools.
Yes, she says, well, oh, sorry, on the previous page, yes.
Yes, because I understood previously from what you
Yes.
said that it was a twig only until she entered the witness box.
No, I think I said earlier, well, when I went to this passage, hopefully I referred
Right.
to that. But by 11:29 on 370, the mother didn't hit her, but the stepfather did. Now that has got to be addressed in the judgment. And it's not.
You see, the difficulty, Mr. Toomey, with I'm having with some of this is that with this much material, there's almost an infinite number of points that can be made about it. But with something of this sort, if the judge has left out something that you say she ought to have dealt with, then that's what the process of clarification that was provided for is for.
Well, I think she had, what the court has, I think, was written submissions which point out, I'm sure this is pointed out in the written submissions, and the judge makes a finding. And that, may I just check my instruction? So Milan Junior emailed the judge, and I've been sent the email. So
That was about permission to appeal, was it?
no, it was about asking for the evidence that corroborated the findings that she made.
Right. I'm sorry, I haven't seen that. So
And that was on the 26th of March.
on the 26th of March. Is that in our bundle?
No, I don't think so. We can provide those emails.
Yes, please. There was an exchange, was there?
Yeah, and I think I'm told the judge responded and said that would have to be done after receipt of the transcript. And of course, we had limited time then. Really, by that stage. Right.
Yeah.
Must-
Email is below. My email is below.
Forgive me, my lord. I just. Right. So, their friend wrote further to the hand-down. We have a duty to advise our clients on the prospects of appeal and to consider whether we require points of clarification of your judgment. We will not be receiving the transcript until the time to appeal has expired, and we wondered whether you would provide us with a written note of your judgment, and particularly the analysis of the evidence on which each on each allegation, so we can advise our respective clients. I think she wrote on behalf of both respective appellants. On behalf of the mother, I anticipate I'll be asking for points of clarification in relation to the evidence supporting the, inverted commas, new allegations, which were made against her following the oral evidence of child 2. And the judge responds, dear Miss Littlewood, I'm afraid I cannot provide a note. The transcript will have to be awaited. Obviously, I'm prepared to extend the time for consideration of any appeal clarification to 2 weeks after receipt of the approved judgment. Can you ensure the transcript is sent to me for approval as soon as possible, please?
The date of the judge's message was?
The 26th of March,
Same day?
same day.
Yes, right.
But anyway, my lord has alluded to the volume, and I say I've sought to try and identify those passages in the judgment which, to use the colloquialism, are the best points in support of the appeal, and just therefore dealing with this final point, we say that really it had to be dealt with properly, and the judge doesn't deal with it, and it's highly significant to the findings she makes. Found one of the findings that it was considered in the wider canvas in relation to the other findings. See the time. Can I try and address the res judicata
By all means.
point? We have referred the court to Re B. I know my lord has endorsed the approach of she was Mrs. Justice Hale in Re B subsequently. So it's a case that has Court of Appeal approval. So can I take the court to that first?
Bookmarked at B12.
Sorry? Thank you. It's electronic 51 in the this is the bit that we've highlighted.
Did you say 51?
Please.
Right, this is Ms. Justice Hale.
Yes.
Right, so there's no strict principle of res judicata
Yes.
in children's cases.
And more than that, that any party wishing to rely on facts previously found needs to draw that to the court's attention. Now, in this case, so in this case, any reference to the previous judgment, I know my lord has referred to the previous judgment and having read it, and that's the 2015 judgment of the district judge. And that appears as C1009, 10th of February 2015. And the relevant passage in the judgment under scrutiny is from paragraph 110 to 122. Which is A109. So in relation to, if I can start then with the judgment itself on the scrutiny at 110. The judge identifies this as findings made by the district judge and identifies at 110 that cross-examination appeared to be designed to challenge or to reopen, relitigate matters, which is Miss Hughes on behalf of the first father helpfully drew my attention to, had all previously been addressed in the judgment of District Judge Dodsworth, the 10th of February 2015. The district judge has already adjudicated on these. A number of hearings have been ineffective. The mother had failed to attend them despite having been personally served. The wording there, failed to attend despite personal service. It's a critical wording. Over the page, 116, she records the district judge's finding that the most charitable description of her evidence was that it was evasive. He found her evidence to be wholly unsatisfactory and that she had lied. At the end of that paragraph, he accepted the evidence of the maternal grandmother, who he found to have given straightforward evidence. Paragraph 118, he found the mother to have provided unsatisfactory, significant, inconsistent, unreliable evidence, and that on material matters she lied and fabricated to the court and the police. And that the allegations of abuse which formed allegation 11 in this case against the first father, paragraph 120, could not be determined. And then 121, despite those findings and the fact they'd never been challenged, the mother maintained her position at the hearing that she was forced into marriage at an early age of 13 and a half, and that her other allegations are true. And she then reminds herself of the Lucas direction. So the substance of these paragraphs is that the learned judge does not, in fact, she's aware of the desire to reopen the facts. In the course of cross-examination...
So can we just go back a step? What Which one of the findings sought in these proceedings is this all relevant to? Which one?
It's relevant to all of them in that if the judge adheres to the findings of District Judge Dodsworth, then the mother, unlike any other participant in the trial, starts out as an established liar.
Right, so that means that you have to apply to set aside the findings. Otherwise they stand for what they're worth. They're not binding upon the judge subsequently, but I mean, there's got to be some process to this.
There has to be a process, and as soon as the learned judge appreciated that these matters were being challenged because there was cross-examination in relation to them, and I can deal with the history because there's more to it than simply arising at cross-examination. The letters of instruction in respect of each expert who had been asked to advise the court as to her psychiatric, her psychological, and her social work, as to those three disciplines, had commented on, and indeed in part been asked to comment on her traumatic childhood. Following on from receipt, particularly of the psychological assessment and the psychiatric assessment, both of which indicated that because of the traumatic childhood, which included being forced into marriage at 13/14, being subjected to rape, marital rape, and beatings throughout her marriage, that she needed to have some therapy and counselling. And in the light of those recommendations, the learned judge herself raised the issue, and it was dealt with at a case management hearing. And the report in the bundle that appears from a suitably qualified and culturally appropriate counsellor, Miss Islam, was the result of an application on behalf of the mother for such counselling to be provided and for there to be a report before the court. And that report expressly asks the author of the report, I can take me to the report, to address the consequences of the trauma she experienced.
Yes, all right. So there's a different narrative running, as you say. But the fact is that there's a judicial ruling in 2015 on matters that are of relevance, to what extent we can leave aside for the moment, to the issues that are before the court in 2021. The judge has obviously got to be aware of and take account of those findings. Does she not?
As if they stand, of course.
Yes, but they do stand. I mean, they still stand until somebody applies to set them aside. You can't just wish them away because you have a different narrative and you don't accept them.
No. But it became clear that there was a pinch point in the course of cross-examination. As the learned judge herself says, it became clear.
Cross-examination of whom?
Cross-examination of the first father, I think.
Right, so he gives evidence.
And yes.
At what point?
And the grandmother.
Right.
And the grandmother.
Right. And they give evidence before or after the children?
After.
Right, so well into the trial.
Yes.
When no application has been made in relation to this judgment, it's made apparent, and people knew it anyhow, that your client doesn't accept the findings that were made, or the absence of findings on her allegations. So, what is wrong with the way in which the judge dealt with it? She seems to have gone out of her way to remind herself that the fact that your client wasn't believed by one judge doesn't mean she shouldn't believe her herself.
Yeah, no, if those findings stand, then of course that's right.
They do stand.
But they do stand, of course they stand, but they stand, and unless they're set aside, And at the point at which the judge was told that these issues were in dispute, then in my submission, what should have happened at that point is that she should have considered whether or not to reinvestigate those matters which were determined and would otherwise be binding on her. Because she is at the heart of this seeking to establish the truth. And she knows that significant matters relating to the truth of the background of this case, and after all, she goes on to make determinations which were before the district judge, albeit not determined by him.
Well, let's go another stage, and let's suppose you're right about that, and that the district judge was wrong and that your client was right. Where does that take matters in relation to the core allegations in this case?
It goes to the heart of her credibility, because as soon as those allegations are accepted and stand, the first point is she starts, unlike anybody else before the court, as an established liar. She starts as not just a liar to the court, but a liar to the police. There is then a later reference in the judgment where the judge says, and still, the worst the effect of, and still today she maintains the truth of these lies, in effect. So she's not just a liar back in 2015. She's a liar today because she's repeating the lies. And she is to be regarded, and in particular, when she then comes on to consider allegation number, I think, 11, concerning the first father, she's to be regarded as a mother who would not go to court for no good reason, who evaded the court process, finally was brought to court, but when she got there, lied. And then the final detriment to her case is that all the experts who reported and provided the chink of light at the end of their report, but particularly Dr. Chowdhury, are found by the learned judge to have proceeded on the basis of facts that conflict with the district judge, and therefore their recommendations stand aside because of that. So the far-reaching consequences, both for the fact-finding inquiry and subsequently the welfare inquiry, cannot be overstated.
How long did your clients give evidence for, roughly speaking?
A day and a half.
Mine was over the weekend.
Yes, she was more than a day.
Yeah.
A day and a half.
Both more than a day,
More than 2 days.
but about a day and a half.
About a day and a half,
About a day and a half.
Each.
with interpretation.
Yes.
Yes. Right, so I'm at the moment, I'm afraid, as you can tell, not really understanding the punch behind this particular point, that you appear to be complaining that your client has had a bad press because she had a judicial ruling against her in 2015, which she doesn't accept. But she nevertheless has a day and a half in order to persuade the judge that she is in fact a reliable witness. So where is, putting it bluntly, the unfairness in any of that?
And in addition to that, the judge gives herself a Lucas direction, so saying, I'm not going to take into account the fact that she's lied previously in deciding whether or not she's lying now.
Well, I'm not sure that's quite the Lucas direction. What she does is she starts as a liar. The lie then has to be factored in with the caveat or with the warning that comes from the Lucas case.
That's what you say she starts the lie. A judge has found her to be an untruthful witness. Yes. Now, I mean, that's maybe unfortunate. That's what's happened.
Yes. No,
I mean, are you suggesting that the judge in these proceedings should simply ignore that?
No, of course not.
Well, then what are you suggesting?
I'm suggesting that as soon as it became apparent to her that there was before her an ongoing challenge.
Right, she should have gone into the process which you've been taking us to in
Yes.
Re-B in the subsequent cases and retried what the judge tried in 2015.
Well, not necessarily. She should have gone into the process.
She should have asked herself whether she should retry.
Yes, and of course, a cornerstone of that is, would it make any difference? That's
And
one.
would it make any difference?
Well, it would have made a difference, of course, because apart from anything else, she would start off on a level playing field as a woman who's not to be determined to be a liar. And the Lucas direction in my submission doesn't save her from. This doesn't put her on a level playing field. Quite the contrary. So the effect of it all for this mother is that she loses the support that she had from the experts who advised. So, for example, at 495A167, the judge comments on the experts advising in the absence of the knowledge that this has already been adjudicated on. But these reports were obtained expressly to address, amongst other things, her childhood trauma. So my submission is that even if it wasn't clear when the first expert, Dr. Ratnam, was instructed, and even when one reads her report and sees her refer to childhood trauma and makes a recommendation for counselling, by the time we get to court and the judge is saying this woman has had a traumatic past, she needs some assistance, will the local authority pay for it, in shorthand? And the local authority are prepared to fund the sessions with Miss Islam. The first question being, how have her traumatic childhood experiences impacted upon her? It was telegraphed from a long way off that there was this challenge.
You say it was telegraphed. Were the experts told about the district judge's findings?
Well, they all had the papers. I know they had all the papers. Yeah, that's right. The independent social worker, Ms. Huda, she expressly refers to the Kafkas report. And of course,
refers to the
Kafkas report.
Yes, we're talking about the judgment of the district judge.
Yeah, but the judgment of the district judge was first and was followed by the Kafkas.
I understand that, but you're relying on the fact that the experts were given a set of instructions that appear not to be concordant with the district judge's findings.
Yes.
And I'm just wondering whether they were told about the district judge's findings.
Can I, in the time that I have, just clarify that point?
But in the end, well represented as your client obviously was at the hearing, you say that with all these things there, then the judge ought to have gone off on a re-B exercise of deciding whether to reopen settled findings. But, and this is not a criticism of Miss Littlewood, as far as I'm concerned, no application was made for that to happen, was it?
No, but can I look at re-B? So if my lord and my lady have re-B, and we've highlighted from page 11 in the report, the first paragraph addressing the Court of Appeal Authority being against the existence of a strict rule of issue estoppel in children cases. She then, Ms. Justice Hale then goes on, she was to say, hence, if the applicant, in one set of proceedings, wishes to rely on findings made in previous proceedings in order to prove a case, the court will have to consider how this should be done. So as soon as it became clear that the first father was relying upon those findings, and/or that the local authority would be likely to rely upon the adverse findings in support of cross-examination of the mother, then the court has to consider how to proceed. And so we say that the court at that point should have paused. It's regrettable. It's one of the matters that occurs sometimes in the course of a lengthy trial when suddenly something, rather like the evidence we complain about, suddenly someone says something that turns up that wasn't necessarily appreciated, but might have been appreciated. And my submission is that the land judge should have engaged with that and not just assumed, as she appears to, that she can do nothing about it. The tenor of her judgment in my submission is she can do nothing about it. The findings are binding upon her. And so would it have made a difference? Well, I've addressed most of the points. I can just finally, I think, ask the court to consider the Kafkas report from 2015. And the fact that the Kafkas officer, so the short history is that the judge has before him a social work report prepared by a local authority in London. And it turns out that the author of that report is a student, and the local authority aren't even sure if he was ever employed by them. So that is something he refers to in his judgment. Subsequently, and the children are seen by the Kafkas officer, and at C1034, he records what the children, the two relevant children, say. In fact, it's three, because the child number 3 is addressed to paragraph 18. She refers to the first father as a bad man. And the reason she knows that is that her two older sisters have marks on their body. And there's the next paragraph, paragraph 19. They told her about their experiences. Now, in the judgment, the judge says that it was the mother's allegations, only the mother's allegations, and that child 3 only learnt about them from the mother. And then he goes through an assessment of what the older two children are saying by using, at paragraph 21, a Kafkas tool. And he says, at paragraph 24, the children were consistent in their accusations. They're both able to give similar answers. The tools have indicated, which he describes earlier, were making their own feelings known. The children were making their own feelings known throughout their interviews. And strong emotions displayed by the children, by that child, were genuine. Mother has frustrated the process, but he puts it in context at the end of 25. Having met with her and hearing the children's experiences, I now believe that mother was likely to have been acting in a protective manner by not engaging with the process she may have believed she was not, allowing the children to see father again and thereafter protecting them from further harm. So the impression given by this Kafkas officer after the fact-finding is of a protective mother and children who are telling the truth. None of this is referred to by the learned judge when she deals with allegation 11, substance. And what difference would it have made if they'd started afresh, if the original district judge had started afresh with this report? Then he might have had a very different view of the mother than the view he took of her without this information. Subsequent to his damning judgment, he discovers from the Kafkas officer that it's likely, on the Kafkas officer's inquiry, that these children were beaten badly and that the mother's response is a genuine protective response. So these were matters that were entirely relevant. Now, it may be that, as I say, things could have been better done, but from our point of view, the bottom line, as it were, for the judge inquiring in a fact-finding hearing is to reach the truth, to get the right answer for the children. And as soon as these profound and important points that went to the heart of welfare and fact-finding were identified to be an issue in our submission, then on the authority of REB, it was incumbent upon the judge to undertake a discretionary exercise. And the reason I say that the appeal should be allowed on this ground is that she didn't undertake a discretionary exercise. She simply proceeded on the basis that those findings were binding on her and there was nothing she could do about them.
Was the judge referred to REB and
No,
was she invited
my lady.
to revisit?
No.
Oh. But I mean, REB shows she has a discretion to revisit, isn't it? If she wasn't invited to exercise that discretion, is it really fair to criticise her?
Well, I hear that. I say, first of all, that a judge should know that as soon as there's a challenge, that res judicata does not apply in children proceedings. And as soon as it was apparent to her there was a significant challenge, there was an obligation on her, because her obligation is to get to the truth. But in any event, the primary obligation is on the person relying on the previous findings if the authority of re B is to be followed. And so the person relying on those findings, it hadn't been spelt out in the schedule, but it was implicit, possibly, but it was certainly the case of the first father that he relied upon them. And the learned judge relies upon them in her judgment in support of the case against the mother.
Yes. Strangely, the local authority wasn't relying on those findings. It was seeking to disturb.
The strange thing about that is that the local authority, because there seemed to be some equivocation, didn't really set out its case in support of allegation 11.
Yes.
And I think there was one point, if I...
Yes, please.
Oh, right, yes. Then from Miss Littlewood reminds me that at C1041, in the light of this report from CAFCAS,
There was a no contact order.
yes, that she must make sure the children do not see him. Yeah. So it's beyond no contact. It's a prohibited steps in effect, the terms of it. Do not allow your children to see this man. But of course, none of that finds its way into judgment. My lords, my lady, are there any... I'm sorry, I've gone on too long.
Not from any of us, I think. Thank you very much. Mr. Toomey, thank you very much indeed. Now, can I just, before we rise, ask Mr. Tuan first, what's your rough estimate?
30 to 40 minutes.
Thank you. And can I come next to you, Miss Hughes?
Well, it may be that my points are covered by Mr. Poole, but I would have thought 20 minutes at the most.
And Mr. Poole?
My lord, I've anticipated about half an hour at the most.
Right. Well, we don't hold you to any of that. We'll see, see how it goes, but just to see which way we're generally pointing. I'm afraid for particular reason we're not able to sit much after 4 o'clock. So if maybe some short period of time, if it actually means that we will complete the hearing during the day, which I'm sure would be convenient to a number of people, but we'll see how we go, and we'll start again at 2 o'clock. Thank you very much.
Well,